Good morning, everybody. I hope today finds you well. Thank you for joining us. My name is Kristen Stratton, and I am the invited guest speaker on behalf of NorCal Services for Deaf and Hard of Hearing to present on the topic of IFSP and IEP procedural safeguards. I'm the parent of 3 children. I have a hearing child who identifies as autistic, and I have 2 children who are deaf, one of whom is deaf with multiple disabilities. I also work as a professional special education advocate, and I'm a hard of hearing adult myself. So I look forward to presenting on this topic. It can be a little bit dry, but procedural safeguards are super important. It's a really essential topic, and it's important that you as a parent understand what your rights are going into an IFSP and IEP meeting. So we'll be discussing the laws that govern IEPs and IFSPs. That's the Individuals with Disabilities Education Act. An IFSP is an Individualized Family Service Plan, and an IPP is an Individualized Program Plan. I'll explain what all of those things are later in the presentation. We'll be discussing the role of regional center in both of those documents. Then we have our IEP, the Individualized Education Plan, or it's sometimes referred to as an Individualized Education Program. And that's governed by the local educational agency. And that's your local school district, sometimes your local county office of education. And we're primarily focused today on the DeafPlus community. And that's our deaf, hard of hearing, and deafblind individuals who may have or who are known to have developmental delays or disabilities. So IDEA parts C and B, those are the components of the Individuals with Disabilities Education Act that control early intervention for children ages 0 to 2 and special education and related services for children and adults ages 3 to 22. IDEA, as it's commonly referred to, is a federal law, and it is all over the United States. So from state to state, regardless of where you live, IDEA is going to be in charge of how those services are going to be provided. Part C services is strictly for infants and toddlers, 0 to right before they turn 3. And that's how we're servicing children who have developmental delays. We create what's called an Individualized Family Service Plan. And primarily it's our California regional centers that are providing those services. Part B services are for our children and adults ages 3 through 22, and they're serviced on a document called an Individualized Education Plan, or IEP. And again, that's the local educational agency, and typically that's going to be your school district, but sometimes it'll be the county office of education that's supporting your student. And there are more differences between Part B and Part C. The infanthearing.org link that I provided here has a really great graphic that breaks down in more detail the differences. So if you have more time, I encourage you to go onto their website and see in more detail the differences between the 2 laws. Okay, so IDEA Part C is all about early intervention. The part that helps me remember what's about Part C and early intervention versus Part B for older children is, I think, C for critical. It's critical that we provide early intervention for infants and toddlers. So that's the way that I like to think about it. So regional centers and IDEA. Regional centers play a very critical role in providing those early intervention services. They are actually nonprofit private corporations that contract with the Department of Developmental Services, and they are tasked with coordinating services and supports for children and later older children and adults with developmental disabilities. So on an IFSP, we initially have to make a referral for a child to receive those services. So a child under the age of 3 is eligible if they have at least a 25% delay in one or more of 5 areas of development: cognitive, expressive communication, meaning how they talk and express themselves; receptive communication, meaning how they understand language; their social and emotional skills; and their adaptive skills, meaning how they take care of themselves in their everyday life; and their physical and motor development. And those delays would be established typically at a doctor's visit with your pediatrician. And some of our families in more rural communities might find more difficulty in accessing an evaluation, but that typically they're going to be identified at your developmental milestone checkups at the pediatrician's office. The second criteria that children can be found eligible for an IFSP is that they have an established risk condition, and also if they're likely to have a developmental delay due to a number of risks. So this would be children that are either identified as having a genetic disorder at birth, or children who are born drug exposed. Those are the examples of risk conditions or other risk factors that we know are going to likely result in a developmental delay and require intervention. So the referral process, it has to be completed within 45 days from step 1 to step 5. From step 1, there's a referral made to regional center. That can be made by the parent. It can be made by the child's doctor. If the child is receiving foster care or social work services, that caseworker can make that referral. And the next step would be whoever is the legal rights holder of the child would sign consent for that child to receive an evaluation to determine their eligibility. And regional center will conduct assessments to determine that child has those developmental delays in one or more of those 5 areas of development. If they are found eligible, then the family will meet with the regional center representative, and together we will develop the IFSP. And from that document, determine what services that child requires during their early intervention time to make sure that they're making progress and to help support those areas where those delays were identified. So you have rights anytime you're receiving early intervention or special education through the school district. IDEA affords rights to parents throughout the entire process from birth all the way to age 22. During an IFSP, the evaluation process must include some sort of evaluation instrument, meaning we have to use some sort of measurement to determine that 25 or more % delay. Parents must be involved, or guardians must be involved. So there must be an interview with the family or guardians. And we must be sure that we're determining the level of function in those 5 areas. We want to make sure that we're measuring and determining in which of those 5 or following areas that child is having a delay. Sometimes it's 1, sometimes it's all 5, but we have to establish a baseline so that we can determine the appropriate way to support that child throughout their time in the early intervention program. Then we have to gather relevant information, and that might include a review of the child's medical history, if they've had any previous therapies or intervention services, and just a comprehensive family history. Okay, our IFSP meetings and services is where we develop and determine what is required. So an IFSP meeting is going to typically take place in the home. Part C requires that services provided to an eligible infant be taking place in the natural environment, and for most children that is taking place in their home. Some services can be occupational therapy. If it's a deaf child, they might have a teacher of the deaf coming into their home. There might be speech therapists coming into the home. So the caveat is that sometimes a child who only has hearing loss or only has cerebral palsy, so those are things called low incidence disabilities. Sometimes those children are serviced by their local school district and not by regional center. So sometimes those children are reluctantly served in the home, and sometimes the school district chooses to offer services at their facility. But the way the law is written, it's supposed to be in the natural environment. But typically, if regional center is supporting the child, and that's the majority of the time, those services are going to take place in the child's natural environment, which is their home. So in an IFSP meeting, you have several rights. You have the right to all the child's records that are developed during the IFSP process, and you can request those at any time. If you make that request, the regional center has to provide those within 5 business days to you. And that would include things called their Title 19 notes, which are the internal notes that your regional center caseworker takes to document any contact that they've made with you. And then we have something called prior written notice, or sometimes called a notice of action. And this is how the regional center would communicate with you anytime it intends to take action, refuse action, initiate a service, or terminate a service. This is a formal way that districts later on, when you're in the school system, and regional centers communicate. And this is one of the ways that you receive documentation that these changes are being proposed or action is being denied. And it also explains your appeals rights. But you'll get really familiar with those terminology, because this is one of the most common documents that you'll receive is a prior written notice or a notice of action. But you're entitled to receive that document anytime there's a change being made to your child's IFSP, even if it's something that you consented to or you requested. You are required to have in writing documentation of that change. Okay, so sometimes when we make requests, we don't agree. And there's an appeals process in place to help resolve disagreements. One of the ways that we can do that is informally. We can go through the supervisor or director process and speak to our caseworkers, chain of command, so to speak, and go up the ladder of the regional center, the supervisor, up to the director level, and see if we can resolve things informally. Sometimes it's just a miscommunication or a misunderstanding of policy. Sometimes it's a formal request that's being made, and it's a formal denial, in which case you're going to be filing an appeal. Within 30 days of receiving a notice of action, you have the right to file an appeal with something called aid paid pending. For example, if Regional Center is proposing to terminate a service that you believe your child still requires, you would file an appeal within 30 days and request aid paid pending. And what that does is it locks in your child's right to maintain access to that service until the dispute is resolved. After 60 days, within 60 days of a notice of action, you can file an appeal. But if you do not file the appeal within 30 days, you do not have right to request aid paid pending. You also have the right to request mediation. You can also go through a due process hearing, and both of those typically involve an administrative law judge. You can also go through the state complaint process, which is a complaint that goes to the Department of Developmental Services. Okay, so when your child is approaching the age of 3, we're going to be preparing to transition them from their IFSP to an IEP. And that is all predicated on whether or not they are eligible for an IEP. And so what happens is at least 90 days before your child turns 3, Regional Center is going to make a referral on your child's behalf to your local school district where you reside, and let your child's school district know that they need to be assessed to determine if they are eligible for an IEP and receive special education and related services from age 3 on. Then on the regional side of things, what they're going to do is they're going to look at your child's eligibility under Lanterman Act. So after the age of 3, for children in Regional Center, there's only a very limited number of eligibility categories where a child can maintain services as a Regional Center client. There's 5 categories. They have to either have autism, epilepsy, cerebral palsy, intellectual disability, or 5th category where they're impacted in a way that manifests like an intellectual disability. And in addition to having one of those designations, they also have to have a substantial disability in 3 or more major life activities. So it's not just that they have an autism diagnosis. That autism diagnosis must also substantially disable them in 3 or more major life activities. If they're found to be eligible in that way, then after the age of 3, they will maintain eligibility as a Regional Center client. And then simultaneously, the school district is also going to assess them to determine if they're eligible for an IEP. If your child is not found eligible for Regional Center services under the Lanterman Act, file an appeal. Worst case scenario, the appeal process also finds that your child is ineligible, but it's always worth trying to appeal. Okay, so IDEA Part B. This is the part of the law that's for children 3 to adults age 22. So this is going to be services for special education and services received at your local school district or county office of education. So an IEP is a legal document. It's part of IDEA still. And under IDEA Part B, we have 13 eligibility categories. And what IEPs do is they provide special education and related services to children with disabilities to ensure that they receive a free and appropriate public education in their least restrictive environment. So we have very strict timelines here in California regarding assessment to determine eligibility for special education. This is not necessarily true. So if you pick up and move to another state, it's not necessarily going to be true in that other state. These are specific timelines to the state of California. So here in California, you as a parent can request your child to be assessed for eligibility for an IEP. And within 15 days of your written request for assessment, the school district must respond with an assessment plan. And they are going to provide you 15 days to respond to their assessment plan. Once you sign that assessment plan, which is your written consent that they can in fact test your child to determine their eligibility, they have 60 days to conduct that assessment. and hold a meeting to review the reports and findings with you and to discuss as an IEP team whether or not your child qualifies under one or more of those 13 eligibility categories. The only exception to that 60-day timeline is if school is not in session, if there's a break of more than 5 school days, or if there's fewer than 30 days left in a school year, the IEP team must resume assessment and complete it within the first 30 days of the new school year. So as a parent, you have the right to request copies of all reports in advance of your IEP meeting, and you should do this. And school districts are required to provide those at no cost to you upon completion of assessment and before the meeting. You also have a right to have them in your native language if English is not your first language. I will be honest with you though, that is very difficult to get and very often a problem for our non-native English speaking families to receive. If that is something that you're struggling to access, please file a complaint with the California Department of Education. So sometimes when we do assessments, we don't agree with the results. Then we have a right to what's called an IEE, or an independent educational evaluation. This means that the school district did tests on your child, a psychologist, a speech pathologist, an occupational therapist, many other people on that team may have done testing, and you as the parent or guardian disagree with the results. You can make a request for an IEE in writing, and that affords you the right to a one-time at public expense repeat of that assessment. The district must respond without unnecessary delay in prior written notice to that request. Sometimes they will deny your request for an IEE, in which case what happens is they defend the report that they did of your child in due process. But quite often, school districts will grant the IEE request. But I believe that many people are under the assumption that if they request an IEE, it's an automatic yes, and that is not the case. They can refuse that request, and the result is that the report must be defended in due process. So an IEP meeting is held at least once a year, and a child is reassessed to determine their continued eligibility for an IEP every 3 years. You have the right to request a meeting at any time, and the IEP team must hold that meeting within 30 days of your written request. There's no such thing as an emergency IEP meeting. I hear people say that, call an emergency IEP, call an emergency IEP. That's not a thing. It doesn't exist. They have 30 days to hold a meeting from your request. Now, if it's an urgent matter, sometimes teams are very accommodating and will try to get a meeting on the calendar right away, but they still have 30 days to hold that meeting from the date of your written request. They'll send you a notice of meeting in writing that indicates where and when that meeting is scheduled, and also defines who is required to attend meetings in the educational law. So if you believe that someone is not present at that meeting that should be required, you are correct. There are required team members that must be in attendance at IEP team meetings. And parents must be given sufficient notice at the parents must be given sufficient notice of scheduled meetings in order to attend. The law is very, very clear on the importance of parental participation in IEP meetings. And so when teams often try to say, well, we only hold meetings on Thursdays, this is the only time we do IEP meetings, the law is very clear that we must accommodate working parents who need to have advance notice so that they can get childcare, so that you can meaningfully participate in that IEP development process. So prior written notice, here we are talking about prior written notice again. This is a very, very important right that you have. Again, anytime there is a proposed action to change something or a refusal of a request that you've made, the document must thoroughly explain why it is that that decision was made, and it must be in detail. It can't just say, you made this request on such and such date and we're saying no. It must indicate why it was the rationale for that school district's decision. So there will also be times when we are using that prior written notice to indicate a reason for doing an evaluation, a change of placement. But there's lots of reasons why we use prior written notice. It's a very important tool to communicate when we're trying to formally document any sort of proposed change or refusal of action or proposed action that we want to take with regard to the child's IEP. And within timeframes, specifically 15 days prior written notice is required for assessment requests. When a parent is requesting prior written notice in response to, let's say you're requesting a specific service be increased for your child, there is not a defined timeline. The law says it's a reasonable time, and case law works that out to be around 30 days. And then for IEEs specifically, the law says without unnecessary delay, which case law again would call that around 30 days. Educational records, again, you have a right to all the documents that are developed and become part of your child's comprehensive file during their time in their public education. So just as before when you were with Regional Center, you have the right to access your child's comprehensive educational file when they're in the public school system. The same timeline applies here also. Within 5 business days of your request, you can actually make this request both orally or in writing, but I always recommend parents put everything in writing. And those records may include, but are not limited to, health and disciplinary records, grades like transcripts, test scores, all the assessments that are conducted on your children's for their eligibility, behavior logs and data sheets, all of their IEPs, any of the service logs. So if your child is receiving speech therapy, occupational therapy, and you want to see how often that service provider actually did provide services, that can all be part of the records request. So with IEP, there is also the due process right and a state complaint right. Here in California, we do have stay put rights. Stay put means that when there's a dispute that arises between what the school district believes and what the parent believes to be appropriate, until that dispute is resolved, the last consented to IEP or the last IEP that was signed by the parent or guardian is what remains in effect until there's a resolution in due process, or there's an order put in place by a judge within the Office of Administrative Hearings. But we don't always have that protection in other states, but here in California, we do. We also have the right to go through due process, which is when you would file with the Office of Administrative Hearings. We have the right to have a resolution session, which is more informal, to try to see if we can come to an agreement prior to involving a judge at mediation and hearing. If that's unsuccessful, then everything that was discussed in resolution would be considered confidential and not be part of a mediation. And then you would go through with the mediation process with a judge. If that's not successful, then the next step would be going to hearing. And by then, typically there's an attorney involved, but not always. And then you also have the option to file a state compliance complaint. And the California Department of Education has a 60-day timeline from the date that it receives a complaint to investigate and issue a decision with regard to the remedy. So another thing I want to make mention of specific to our deaf and hard of hearing families is language access rights. So our children who are signing, our children who have deaf parents who sign, both of you have the right to have your native language rights honored in the meetings and in the services that your child receives. In IEP meetings, you do not have to bring your own interpreter. In an IFSP meeting or later, if your child maintains eligibility with Regional Center and you have an IPP, you do not have to provide your own interpreter. You are entitled to one in order to participate in all of those meetings. Your child similarly has language access rights as well, both in an IFSP and an IEP. So these are some wonderful resources available that better explain in great detail your protections under all the laws. But I want to make mention specifically of the deaf advocacy letters from the National Association of the Deaf. They have pre-printed letters that very specifically define all of the legal obligations by various organization types. So if it's a medical professional versus a educational entity versus a public access place like a restaurant or an entertainment venue, they have a wonderful catalog of letters that you don't have to reinvent the wheel. You can just literally go on their website and download the letter and send it to the school district, and it entitles your child and you a right to communication access. The other document that's very important here I want to point out is the effective communication document from the Department of Justice, which outlines the obligation of the school districts to protect your child's right to effective communication. So very often people assume that because your child has an IEP, that means that their protections under the Americans with Disabilities Act are no longer in effect, and that's just not true. Your child is simultaneously protected by IDEA and the ADA. And I would like to say that if there's any questions regarding your rights, please reach out to NorCal Deaf Services. They have a wonderful resource of advocates and professionals who are more than happy to guide you through this process. It can be very overwhelming as a new parent to try to navigate the IFSP and IEP process. It's all very new, and especially if you have a DeafPlus child who has multiple disabilities, maybe lots of medical appointments, lots of specialists, it's really important to have someone who understands the process come alongside you and explain things and answer your questions that are specific to your child. So please don't hesitate to reach out, and thank you so much for your time and for joining us this morning.